I'm wondering whether in the party's arguments the ministerial code may be given more significance than it really deserves. Under Section 31 of the Scotland Act, a person in charge of a bill shall, on or before the introduction of the bill, state that in his view the provisions of the bill would be within legislative competence. Now, the person in charge of the bill may very well not be the Lord Advocate. But in the case of a bill of this nature, it would be some minister in the Scottish Government, I presume.
Yes.
And that person, in order to make the requisite statement, would require legal advice from somebody. And obviously the law officers are the authoritative source of legal advice as far as the Scottish Government is concerned. Am I right so far?
Yes, that is exactly right, my Lord.
Now, it so happens the ministerial code formalises that in a document that's of an administrative character. It's not a piece of legislation, the ministerial code. But leaving aside the argument about Section 33 references of bills for the moment, if one leaves that out of the picture, if the person in charge of a bill is not clear as to whether its provisions would be within legislative competence, or if the person from whom he would receive advice about its legislative competence isn't clear, I wonder whether there's any problem about saying that would be a question arising, that the competence of the bill would be a question arising by virtue of this Act.
Yes, I agree with that, my Lord. The requirement for the certificate rests with the minister introducing the bill.
Yes.
And so the whole issue about legislative competence arises by virtue of the Act.
Yes.
So the minister who's proposing the bill has to consciously and responsibly apply their mind to the Section 31 test. As a matter of law, the minister is not bound by the Lord Advocate's advice, and there may be circumstances in which the minister could properly take a different view. However, that view would really require to be underpinned by rationale, on a rational basis, and a view reached in good faith. And even though the ministerial code is there, and it requires the bill to be cleared by the Lord Advocate before the statement's made, there's no doubt that the whole issue of this, where this issue arises by virtue of Section 31.
Yes, and we have to remember that by virtue of is a phrase of a statutory definition.
That's right.
Which includes under.
Yes. So I think the Advocate General makes a point that I'm introducing a self-imposed barrier by virtue of the way in which I've looked at matters and applied the ministerial code.
Yes.
And for that reason, this issue doesn't arise by virtue of the Act. But it plainly does, because the whole question of legislative competence has to be addressed by the minister presenting the bill to Parliament, and he or she could not do so if he didn't consider it was within competence.
Thank you.
But just to follow on that, you just said they couldn't do that unless they considered it to be within competence. But what is it that prevents them from taking a different view from the law officers if the law officers say, I don't believe this is in legislative competence, but the person in charge has the view that it is? What is it that stops them from saying, thank you for your advice, but I am prepared to make that statement?
Well, that would be a significant departure from the way in which government operates currently. But there is nothing, as I've said, as a matter of law, the Minister is not bound by the Lord Advocate's advice, and there may be circumstances where they could properly take a different view. But that different view has to be based on a sound rationale and reached in good faith. And the norm is that ministers of the Scottish Government take advice from the law officers who are Scottish ministers, and that it would be an unusual circumstance for it to be reached that the minister didn't accept or agree with the law officer's advice. But in principle, my lady makes a reasonable point.
And could I just check if I've understood one implication of the point that you've just been making in answer to my Lord Reid? As I understand the position that you're adopting, the devolution issue that arises in a case such as this, you say, goes to whether a bill is within the legislative competence of the Parliament, and that's potentially legislative competence under any of the heads in section 29(2). It's page 129. So it's not just confined to reserved matters. It would could be in relation to breach of restrictions in Schedule 4 and so on.
Yes, but the issues here are particularly, the issue in this case is the question of a reserved matter, of course.
Yes, yeah. No, the reason that I just wanted to check that is the way that you're putting it, because we're going to come on to an argument, as I think, from Sir James about bifurcation of issues, that you can get a reference which wouldn't resolve all matters because you're concerned with reserved matters.
Yes,
but in fact, as I understand your argument, a reference under paragraph 34, because it's about a devolution issue, if it's framed as the devolution issue is specifically about the legislative competence of the Parliament, is capable of encompassing any or all of the matters in section 29(2). In other words,
I think that
the bifurcation problem may not be such a problem as was suggested in the written argument.
Well, I think I come on to deal with bifurcation, and I could possibly come back to that.
Yes, certainly. I just wanted to check that I was understanding your argument correctly.
To that point. Yes.
All right.
Well, yes.
So I think the question that Lord Reid was asking was about section 31. I'll come back on paragraph 34. I think it does relate solely to reserved matters. I'll come back on the point that my Lord Sales has made in answer.
Yes, I mean, you can only the point I was wanting to explore really was in relation to the argument which Sir James makes in his written case, that really the connection with the Scotland Act is not sufficiently direct because it's mediated through internal practices of the Scottish Government reflected in the ministerial code. So the point I was wanting to explore with you was whether really the nub of the matter is that where there is uncertainty on the part of the Scottish Government or the responsible minister in it as to whether a bill would be within legislative competence, then that issue of competence would be an issue arising under the Act, which you might want to refer so far as you competently can, but you are you not limited by the fact that references under paragraph 34 can only be of devolution issues.
Yes, that's right.
And your whether or not the matter could go any wider in terms of the definition of devolution issues in paragraph 1 of Schedule 6, you're confining yourself to the issue of reserved matters.
That's right.
Yeah.
Yes.
So I think you have to accept that that if there were room for a question about competence on another basis, such as impinging on legislation which was protected against modification,
yes,
you wouldn't be able to refer that issue.
No, that's exactly right, yes.
said a little while ago, you referred to the possibility of an individual member, not a minister,
Yes.
introducing a bill along similar lines as the bill you're referring. Could you just clarify whether you say that that would be then the person in charge of the bill who would have to make that statement?
Yes.
But I think you were saying they would not need to seek the advice of the law officers because the ministerial code does not apply to them. They could just state their view.
Yes.
Could you just clarify whether, if that were what were about to happen, do you say that you would have a power to refer the question under paragraph 34 in that situation?
I'll come back. I'm not sure about, I need to think about that point and I'll come back with a particular answer on it. But I think what would be helpful to know is that a member's bill is a public bill introduced by an individual MSP, and the MSP in charge of the bill has to make the statement that the bill would be within competence in their view, and that wouldn't require taking advice from the Lord Advocate, government legal advice. The bill also can be introduced with a positive or negative statement on competence by the presiding officer, and the Lord Advocate, Advocate General for Scotland and the Attorney General can refer a bill which is considered to be outside competence to the Supreme Court, as with any bill after the bill is passed. So there is a mechanism within the Scotland Act to allow for a private member's bill at a later stage after introduction to be referred in accordance with the statutory scheme. So it's just a different procedure, but there is mechanism under the Act for a reference after the bill has been presented and has passed through parliamentary procedure.
I would be interested to your answer, if someone who is not a minister was proposing to introduce a bill, had stated that in their view it would be within legislative competence, you or another law officer disagreed with that, do you say that you would have power to refer the bill before it was introduced?
Mm-hmm. Yes, I'll consider that point against the fact that there is procedure within the Act for the appropriate reference to be made in accordance with the legislative provisions of the Act, and it might be that in that situation that should be the course that's followed. But I'll take that point and come back on it.